Hello class, and welcome to a quick discussion about the judicial branch, which is going to be in Article 3 of the Constitution. We've gone over the legislative branch, and the legislative branch is responsible for making policies and laws. The executive branch, which is Article 2, is in charge of enforcing laws. The judicial branch is Article number 3, and its job is to interpret the laws. Now, there's a lot of different places where we get laws. Mostly they come from like statutes that are passed by a Congress, whether it's the state or federal level. Then there are also things like constitutional law, but we typically break the law down as far as how people are either charged or how they try to seek some kind of payment into criminal and civil cases. So very quickly, criminal cases, we have misdemeanors and felonies. Misdemeanors are lesser crimes, felonies are more severe crimes. Most states, for example, if it's a misdemeanor crime, will put somebody in jail no more than a year. With a felony, depending on how serious it is, if it's something like murder or rape, people can actually spend the rest of their lives in jail. Civil cases are where people actually sue like a company or they sue another person. There's no jail time with a civil case. Most of the time with civil cases, what people are seeking is some sort of form of payment, something to kind of make up for wrongdoing. Of course, the most common civil case is actually a divorce, because if two people basically get a marriage license and they're legally put together, the only way to break that kind of contract is for one partner to sue the other. So as you read about the judicial system, hopefully you know at least those sort of two main differences between the criminal and civil systems. In a criminal system, typically there's a prosecutor who will decide whether or not to bring charges, or sometimes prosecutors will use grand juries to do that. In a civil case, you have a plaintiff and a defendant, and both basically hire lawyers to take on their case. In criminal trials, a lot of people who can afford a defense attorney have the ability to do that. If a person's charged in a criminal trial and he or she cannot afford an attorney, the court will appoint one, if it's something that somebody's done that could result in jail time. We have a dual court system. The dual court system basically refers to the fact that courts are set up where we have a federal Supreme Court, and then we have other federal courts underneath it, and then each state also has its own court system. And so things can begin at the state level, for example, and eventually make their way to the federal system. Federal cases don't come back down, don't go to the states. Once it's a federal case, it doesn't come back necessarily. But for example, at the state level, most cities have some kind of municipal court, which is a city court. A lot of times city courts are listening to things that are maybe not that serious. A lot of misdemeanors go to city court. At the state level, usually there's some form of a district court, and district courts will oftentimes, depending on the size of a population, make up more than one county. So for example, if you live in Northeast Arkansas, you may be in the district that includes Crittenden, Craighead, Poinsett, Clay, and Mississippi counties, but that's a larger district. And then at the state level, you have an appellate court, which basically hears court cases that are appealed from the district level. And at the state level, we have a state Supreme Court. At the federal level, you actually have federal district courts. There are dozens of these spread throughout the country, so depending on where you are, if you had a federal case, you would probably be assigned to the one closest to your geographic area. District courts hear cases for the first time. At the federal level, there are also appellate courts. If there is a court case that makes it through the state court system all the way up to like the state Supreme Court and it's appealed from there, it would actually go directly to the Federal Court of Appeals. It would not actually go to the federal district level. It would bypass the federal district courts and go straight to the Court of Appeals, as is a case that comes from the federal level. The federal district level would go to the Court of Appeals. We have about 14 appellate districts all throughout the country. So again, most of these districts encompass more than one state. And so these are very, very important courts because they're deciding stuff that has come from the states, and they're also deciding issues that have been decided at the district court level. Now, and that's an important thing to understand too, because in the Constitution there's a national supremacy clause. In other words, if it's a state issue and a state law has been challenged in some form or another, it is kind of up to the federal courts to determine whether or not what the states are doing, whether or not it's constitutional or not. Then, of course, we have a Supreme Court. The Supreme Court of the United States, of course, which is in Washington, D.C., is the highest court in the land. It's going to hear cases that are appealed to it from the appellate court. The Supreme Court also has appellate jurisdiction. It also has original jurisdiction. Cases, you can actually, if you argue that it's a constitutional issue, cases can be brought to the Supreme Court for the first time. It's also something that's important for people to know is that usually for the Supreme Court to hear a case, there does have to be some kind of argument that needs to be made at that high level. For example, if there's an issue with like the 14th Amendment to the Constitution, a lot of times that's something that'll jump almost directly to the Supreme Court. The Supreme Court is considered to be the final authority in those decisions. And so there are cases that have gone, for example, from an appellate court in a state, and there's been an appeal made to the Supreme Court to go ahead and listen to it because it deals with something that's really constitutional that maybe there's just a need for the Supreme Court to weigh in on right away. The Supreme Court currently has 9 different judges, and I encourage you to look them up. As of now of this taping, there are judges who typically are considered to be a little bit more liberal, like Ruth Ginsburg, David Breyer, and Elena Kagan, Sonia Sotomayor. And when this was taped, there are judges that are considered to be more conservative, like Samuel Alito, who the current Chief Justice of the Supreme Court is John Roberts. Neil Gorsuch has been a more recent appointee. And so, and we still have Clarence Thomas is on the Supreme Court. And so these are judges that are considered to be a little bit more conservative. And so of the 9 judges on the Supreme Court, and they basically have it set up to where most decisions are not going to be even. So there's always a tiebreaker. There are times when Supreme Court justices will actually recuse themselves because of a conflict of interest from the court. If you're somebody who already has clearly made an opinion about a case before you've heard it, or if there is some kind of a conflict of interest that could make it to where your decision would obviously be questionable, then obviously you might want to step down and allow the other judges to be the ones to decide. But the Supreme Court, the makeup of it has changed over the years. We have definitely have, like currently the 9 justices and Justice Kavanaugh is actually the one that I haven't mentioned yet. Of those judges, they're subject to change. They do serve life appointments, but they can retire. Someone like Sandra Day O'Connor actually retired. Many judges actually will die on the bench, not literally necessarily, but many of them will serve until they pass away because they have lifetime appointments. They are appointed by the President of the United States, and they are confirmed by the Senate. And so, there are people who, when voting for a president, will actually consider who the Supreme Court judges might be from that president. And of course, the Supreme Court has changed a lot over the years. There have been at times more than 9 judges. There have been, I think, at times even less than 9 judges. But really quickly, in early American history, really up until the Civil War, what you'll find in your reading is that a lot of the cases are the ones that are considered to be landmark cases actually dealt with federal issues of federalism between states and the national government. After that, after the Civil War, up until about World War II, there were quite a few landmark cases dealing with legislative issues. For example, things like the Social Security Act was challenged to the Supreme Court to see whether or not it was constitutional. What we have found is since World War II, many of the landmark cases actually deal with civil rights and civil liberties issues, as far as the role of government in protecting people and protecting all groups of people. Many of the landmark cases, like the Brown versus the Topeka Board of Education case in 1954 have kind of had to deal with things like that. So hopefully this is kind of giving you an idea of the importance of the judicial system, and in particular the importance of having a Supreme Court. There has to be some kind of body that has some final say, or quite frankly we would just keep kind of spinning around and round and round. So as always, if you have any questions or if you have any concerns, please feel free to email me.